All right, let's get right into it. Today we're going to unpack a really powerful and sometimes pretty controversial legal tool called Quo Warranto. It's got an ancient-sounding name, but believe me, its consequences are incredibly modern.
So let's start with a fundamental question. Imagine you see someone holding a powerful public office, and you're thinking, wait a minute, does this person even have the legal right to be there? We're not talking about their policies or politics, but their basic eligibility. How do you actually challenge that?
Well, the answer has a very old, very Latin name, Quo Warranto. It literally means, by what authority? And that's exactly what it is. It's a formal legal demand that forces someone to prove to a court that they have the actual legal right to be in the position they hold.
Okay, so let's get into the mechanics of this. Like any legal process, Quo Warranto has very specific rules. And to really get it, we need to understand two key things. First, who can be the target of this kind of challenge? And second, who actually has the right to start one?
Now this slide gives us a handy way to remember the targets. Just think UPC. First, the challenge can be against a usurper, which is just a legal term for someone unlawfully holding an office they're not entitled to. Second, a public officer who does something that legally forces them to forfeit their office. And finally, you can even challenge a corporation if it's operating without the proper legal authority.
So we know who can be challenged, but who gets to pull the trigger? Who gets to start this whole process? It's not as simple as any random citizen deciding they want to file a lawsuit.
There are basically three ways this can happen. The first is a direct lawsuit by the state itself, usually through its top lawyer, the Solicitor General. The second is also started by the state, but it's prompted by a private citizen who acts as an informant. This is called an ex relatione action. And then there's a third path. A private person can file. But, and this is a big but, only if they meet a very, very specific condition.
And this is where it gets really important. Each of these three avenues has its own set of rules, its own keys to unlock it. You can't just pick one at random. The specific circumstances of the case dictate which path is even an option.
This table breaks down the differences perfectly. You see, when the state acts on its own, it files in the name of the republic and doesn't need the court's permission to get started. But when it's acting on a tip from a citizen, it does need the court's approval. Now look at that last column for the private person. They file in their own name, but check out that last row. This is the absolute key. They must be able to prove that they have a clear, personal right to that specific office.
And all of this points to the core philosophy of Quo Warranto. It's not designed to be a tool for personal fights or political rivalries. It's built on the idea that the legitimacy of a public office is a public question, not a private one.
This quote just nails it. The legal system sees this whole thing as a matter of governmental legitimacy. It's about making sure the public can trust that its officials are legally qualified, not about helping one person beat another in a political spat.
And that has a huge real-world consequence. It means you, as a concerned citizen or a taxpayer, can't just go to court and file a Quo Warranto lawsuit on your own. Your interest is a public interest, and the law says that interest is represented by the state.
So let's make this super practical. Imagine you uncover rock-solid proof that your mayor doesn't actually meet the residency requirement to hold office. You cannot march into court and sue them yourself. Why not? Because you aren't personally entitled to be the mayor. The correct procedure is to take your evidence to the Solicitor General, who then decides whether to act on behalf of the public.
Okay, we have gone through the theory. Now let's see how all these rules played out in one of the most significant legal cases in recent history, the ouster of Chief Justice Maria Lourdes Sereno. This is where we see exactly how these abstract ideas work in a really high-stakes, real-world scenario.
So in 2018, in a move that was pretty much unprecedented, the government, through its Solicitor General, filed a Quo Warranto petition. The target? The sitting Chief Justice of the Supreme Court. The argument was simple. She had no legal right to hold the office.
And this, of course, immediately raised a giant constitutional question that everybody was asking. The Constitution lays out a specific process for removing a Chief Justice, and that's impeachment. So how could a court case possibly be used to do the same thing?
Well, the Supreme Court's decision hinged on this very distinction. They argue that impeachment is for an official who was validly appointed, but then committed some kind of misconduct while in office. Quo Warranto, they said, is completely different. It challenges the appointment itself, arguing the person was never qualified to begin with, making their appointment void from day one.
So what was the specific reason she was supposedly unqualified? The government's case zeroed in on a constitutional requirement for all judges. They have to possess proven integrity. And in this case, the government argued that integrity wasn't just a feeling, it was something that could be measured with paperwork.
And that brings us to the core piece of evidence. The council that vets judges uses the filing of official financial disclosures, called SLNs, as a measure of integrity. And the petition against Serino claimed that 9 of these required filings from her years in government service were missing.
In the end, the Supreme Court sided with the government. Their ruling said that the missing SALNs meant she failed the proven integrity test before she was even appointed. This made her entire appointment void ab initio from the very beginning. Legally, that made her a usurper, not a validly appointed official. And if she was a usurper, the court concluded then Quo Warranto was the correct legal tool for her removal, not impeachment.
So what's the takeaway from all of this? Well, the Serino case really cemented Quo Warranto's role as this incredibly powerful tool in modern government. It acts as a kind of check on power, a legal backstop to the normal political processes.
And you can see it's used a little differently depending on the job. For someone who's elected, the challenge is usually about their basic eligibility, citizenship, residency, things they needed before they could even run. For an appointed official, the focus is more on the legality of the appointment itself. Did they meet every single qualification, just like we saw in the Serino case?
In the end, that is its purpose on paper. It's a legal safeguard designed to protect the integrity of our public offices by making sure the person sitting in the chair has met every last legal requirement to be there. It's the system's way of asking for the receipts.
But the Serino case also highlights just how much power this tool holds, and it forces us to really grapple with the fine line it walks in our modern political world.
So is Quo Warranto a vital constitutional safeguard that ensures only qualified people hold power? Or does its use, especially against the highest officials in the land, risk turning it into a powerful political weapon? That's the critical question at the heart of the debate today. Thanks for joining us for this explainer.